Is the use of Section 33 of the Canadian Charter of Rights and Freedoms subject to constitutional limits other than requirements of form? Answer, yes. What's the reaction to this? Well, it's not good. Mark Carney's government is pushing the Supreme Court to shackle one of the most important powers provinces have. Section 33 of the Charter of Rights and Freedoms. That raises serious questions about provincial independence, especially when the same government has argued that courts should stay out of federal decision-making. So why should courts step in when it comes to the provinces? Let's take a look. So, ladies and gentlemen, there is a very, very important case going on right now, and this is what it's about. Lawyers challenging Quebec's Bill 21 tell Supreme Court it violates Constitution, sets dangerous precedent. So the hearing started today, and here's a summary of what happened. So Monday kicked off 4 days of hearings at the Supreme Court of Canada for the legality of Bill 21, Quebec's religious symbols ban for public sector employees in positions of authority. The law has been in place since 2019 and has survived multiple legal challenges so far. Bill 21's legality hinges on whether the provincial government's use of the notwithstanding clause in the text of the bill is valid. Lawyers representing groups from the educational sector and civil rights advocates argue the law sets a precedent for wider use of the clause, which can temporarily override parts of the charter. The justices at several points challenged arguments that the notwithstanding clause was being used improperly. The Attorney General of Quebec will present the province's defense of Bill 21 on Tuesday. So, what is this all about? Well, we made a video about this probably a couple months ago when, the initial rumblings of this were starting. But what this is about is a section of the Canadian Charter of Rights and Freedoms, Section 33. And what that basically says is that if a court makes a ruling and the province doesn't agree with that ruling, like the provincial government, they can use Section 33 to override the court. Now you may be asking, well, why would they want to do that? Well, it's not necessarily about why would they want to do it, is whether they should do it. See, all this comes back to the principle of government supremacy or elected representative supremacy. So this is why at the federal government, Parliament is supposed to reign supreme, right? Because they're chosen by the people, they're representing the people, and they legislate on behalf of the people. Courts do not legislate. They do not act on behalf of the people. They are not put there by people. So this is where this debate comes to pass. So if the court makes a decision that has really wide-ranging consequences, the question came up while the Constitution was being drafted, what do we do if we're the provincial government and the court makes a ruling that we feel is very, very wrong? We need some way to protect ourselves from that so that the elected representatives can actually override the court system and the judiciary. So this is where Section 33 comes in. Section 33 allows a provincial government to override a court decision. And sometimes they can use it preemptively. So in this case, Quebec, they put through Bill 21. Bill 21 is essentially a ban on religious symbols and religious garments when it comes to people in positions of authority. They are extremely secular in Quebec, as most people know. This is where this law came from. So they preemptively used Section 33 to prevent a court from overturning Bill 21. So that's what that did. Now, there have been many legal challenges to Bill 21 because this would prevent hijabs, it would prevent turbans, it would prevent many different types of religious headwear, and it also prevents religious symbols to be used in these cases. So you may say, well, Maybe there's a valid point to having that law in there. Other people may say, well, there's a valid concern to preventing the expression of religious freedom. This is the line we have to walk. However, what is happening now is Mark Carney and Sean Fraser, they have submitted a factum. They as in the government. It's not just those two got together, but they've submitted a factum, and they are actively supporting a push to have the Supreme Court review this case and rule that Section 33 of the Charter, there needs to be a lot more limitation on that. And it could be a big problem. Why? Well, before we get there, let's see what the government's position is first. So, ladies and gentlemen, as always, we go to the source. This is the actual document that the government of Canada filed in this case. Okay, so this is from the Attorney General of Canada, and you can see all of the different litigants at the top, but you can see factum of the Intervenor Attorney General of Canada at the bottom there. And this is what they're bringing to the table. So the Attorney General of Canada will address the following constitutional questions. Is the use of Section 33 of the Canadian Charter of Rights and Freedoms subject to constitutional limits other than requirements of form? Answer, yes. Can the courts, in the exercise of their inherent jurisdiction, declare that the rights and freedoms guaranteed by subsection 2 or 7 to 15 of the Charter have been violated despite a valid use of the Charter? Answer, yes. This is kind of the problem, folks. More specifically, the Attorney General of Canada submits that Section 33, interpreted in light of its context and the scheme of the Constitution, A, cannot have legal effects beyond subsections 2 or 7 to 15 of the Charter, B, grants only a temporary legislative power that cannot result in the irreparable impairment of the rights and freedoms guaranteed by subsection 2 or 7 to 15 of the Charter, and C, does not oust the jurisdiction of a court to declare that the rights and freedoms subject to Section 33 have been unjustifiably limited within the meaning of Section 1 of the Charter. So the whole point of this is the courts are allowed to review if a province has properly invoked Section 33 of the Charter, but the spirit of the Constitution and the spirit of Section 33 is to not allow a court to be able to limit that power. That's the difference. And this goes back to why? Because it goes down to the principle of the people that have the ultimate power in this country should be elected, that way chosen and representative of the people, the will of the people, versus people that are appointed by politicians in the courts. And that once they're in there, you don't really get them out. So they're not elected, they're appointed. And they're not acting every day on behalf of the people. They're acting every day based on what they see fit in terms of the interpretation of our laws. So, what's the reaction to this? Well, it's not good. So it's from the National Post. Ted Morton, Carney demands Supreme Court strip provinces of right to pass their own laws. There's an important constitutional conference going on in Ottawa this week. Haven't heard about it? Don't feel badly. Neither have most provincial governments, who stand to lose one of the most important powers they acquired with the adoption of the Charter of Rights and Freedoms in 1982. The provincial premiers have not been invited. There is none of the pomp and circumstance and media coverage that normally accompany constitutional conventions. No, this will take place very quietly in the chambers of the Supreme Court, where the Mark Carney Liberals are asking the Supreme Court to effectively amend the Charter by imposing new restrictions on how provincial governments can use their Section 33 notwithstanding power, also known as the Notwithstanding Clause. The occasion is an appeal from Quebec dealing with Bill 21, which prevents some civil servants, most notably teachers, from wearing religious symbols at work. Bill 21 also includes the use of Section 33 of the Charter, which states that a law, quote, shall operate notwithstanding a provision included in Section 2 or Section 7 to 15 of this Charter, end quote. This notwithstanding power allows a legislature to exempt one of its laws from any judicial declaration of invalidity arising under the designated sections of the Charter. Its practical effect is to give elected governments, rather than judges, the last word when there is a disagreement over the practical meaning of a right. And that's where the political fight begins. In 1981, Trudeau's original draft of the Charter had no notwithstanding clause. Section 33 was added only after 8 provincial premiers, or the Gang of 8, made it clear that they would not accept Trudeau's proposed charter without it. Hard late-night bargaining resulted in a compromise. Trudeau got his charter, the provinces got the notwithstanding clause. Outside of Quebec, the notwithstanding clause was little used over the last 3 decades. Recently, however, there has been a resurgence in the provincial use of the notwithstanding clause. Section 33 has been used in 10 different provincial laws since 2018, not just by Quebec, but also by Ontario, Saskatchewan, and Alberta. Sensing the risk of losing the strategic value that the Supreme Court's charter decisions give to the federal government, i.e. disallowance in disguise, the Carney Liberals have now asked the Supreme Court to impose new restrictions on when and how a government can use the clause. Carney's government is asking the court to rule that the preemptive use of the notwithstanding clause is unconstitutional. Ottawa's legal argument contradicts both the text of Section 33 and its clearly documented purpose. Legal commenters are already predicting that an adverse ruling against Quebec and its provincial allies could, quote-unquote, inflame separatism and lead to a national unity crisis. I agree. The logic of Section 38(3) of the Constitution, which permits opting out of certain amendments, should apply to Section 33 as well as to the province's traditional constitutional powers. Section 38(3) gives every province the legal right to opt out of an otherwise valid constitutional amendment if the amendment removes one of a province's enumerated powers. This is where we are. We're at a point where, well, we get to see hypocrisy on full display. And it's hypocrisy because these types of stories, they make me think of other situations in where the Liberal government was in. We look at the prorogation hearing back in January of last year, and I was in court for that. And I remember the government standing up and arguing that this shouldn't even be here. The government shouldn't be in court for this. Why? Because they're saying that the judiciary should have no basis to even review this. Shouldn't even be there because Parliament is supreme. Because government is supreme. And the courts should stay out of it. They made essentially the same argument when it came to the Emergencies Act, that the court should defer to the judgment of the government of the day in order to actually make their decisions. Therefore, the government shouldn't have even been ruling on whether the Emergencies Act was constitutional or not. This is the issue. So it brings us to here. So the Liberals are saying, well, in our case, the government shouldn't be subject to the courts. But when it comes to the provinces, they have a completely opposite position. They're saying, oh, absolutely, yeah, the courts should be all up in their business. Now, in this case, this is the tricky part, because we have a debate about religion going on in this country, C9. Very dangerous bill. And we also have this situation going on in Quebec with Section 33 and the province trying to legislate that you can't wear religious symbols and you can't wear religious garbs. Teachers can't wear it, and potentially folks in higher positions in the Quebec government shouldn't be able to do that either. So how do we balance this? Because if we get that balance wrong, we don't just lose a legal argument. We change who actually has the final say. We may not like the law that Quebec is trying to pass, but that decision is a lot easier to change through an election and legislation change than it is through a Supreme Court ruling. And at least that way, it keeps the power with the people who are elected, which is what democracy is all about.